Everybody. Today we are going to do something a little bit different. We are going to just go into your questions and answer all your questions, and hopefully we give opportunity for more people to get your questions answered. I'm Sam Shihab.
I am Brian Burke, and we'll be back in just a moment.
All right, so just a quick introduction who we are. My name is Sam Shihab, and my partner.
Brian Burke, that's me. We're with the law firm of Sam Shihab and Associates, named after this guy right here. And normally during one of these sessions, Sam, we sort of try to do a deep dive into a specific topic, but sometimes people want to ask us questions.
Yeah, we've had a lot of requests that people want more questions, more interested in getting their questions answered. So we figured we just do a session to answer questions, and hopefully, if we have time, we can definitely talk about a topic or a concern or something that we can pull from the questions.
Yeah.
And then go right in.
Oh, sure. And Lord knows we have things we can talk about. And, if we have the opportunity to do deep dives on some of these questions that we get asked, that sounds excellent as well to me.
We received questions before the stream goes live on YouTube, and these don't get through to us, but we are printing them now, and hopefully we can bring them to you and also answer them as well. So for those who logged in early and didn't get a chance to get their questions answered first, we will get them as soon as we get them here in the office. But without further delay, Sky Limit has a question.
I thought skies don't have limits, but I digress. If someone has an adjustment EAD based on EB5 and H4 EAD based upon spouse's H1B, how will USCIS know which EAD that person has used? Now, Sam, this is where I'm going to pat myself on the head and say, that topic we did last week was a really good one, because one of the things we discussed last week is how will USCIS know if I have an adjustment and like a derivative EAD, which one are they going, how are they going to know? And the answer is, well, there's a couple potential ways. Well, first of all, generally speaking, they're not going to know. I-9, when you give that to an employer to join a company, that I-9 form is going to go into their drawer and probably never going to be seen by anybody outside that company. So there's not a little bell or alarm that goes off at USCIS when you abandon, H4 status, for example, and use an adjustment EAD. But how might USCIS come to know that you've left behind your non-immigrant status and changed over to a pending adjustment EAD, for example?
Well, the I-9 is really the only way, or through an application in which maybe there's a question and you answer it.
Yeah.
But I do have a kind of an overriding question on top of that one. Does it really matter?
That's a great point.
Does it really matter? Let me change the question just a little bit. Let's assume someone has an adjustment EAD based on EB5 and has an H4 EAD based on spouse H1B.
Yep.
And that person submitted to their employer the H4 EAD for employment. Mm-hmm. And then that person's spouse, who's holding the H1B, was laid off. Mm-hmm. Okay? And lost his H1B, and therefore the spouse lost
H4, sure.
her H4. However, the spouse had an EB5 EAD that she never presented.
Sure.
To the employer, and it stayed in the drawer. Nobody saw it except USCIS and her, and she worked for a year before she discovered that she never presented that EAD to the employer. Is there a violation of the law?
No problem whatsoever there. I mean,
there's no violation of the law.
The employer didn't met its obligation. They confirmed, work authorization per I-9, and you personally have your EAD. I got to worry about scenarios like that, Sam, though, because, imagine it's, flip-flopped. You're relying upon that H4 EAD, and, you think it's valid, right? But so you don't bother with renewing the adjustment EAD. I very much worry about people in scenarios where they they don't bother getting the adjustment EAD, for example, and then think they don't need it. And
That's why you want to get as many EADs as you can get, even though you don't use them.
that's the moral of this story for sure.
I've had cases during DOL audits in which a person worked outside their work location and they want to
Like an
do
H-1B?
Yeah, an H-1B out of, like they said, well, there's no LCA for this location.
Gotcha. Yeah.
And I presented EAD card.
Yeah, you win.
And I went, and they said, oh, okay, take him off the list. He has another reason, another way to work.
I guess you were really kind of underlining an example. Somebody can ask, for example, in the Department of Labor, in this scenario, asked about, hey, where is this person authorized to work here? And when I think about getting asked about how will USCIS know if I'm using an adjustment EAD or an H-4 EAD, if they're curious, if they have a reason to be concerned, and I usually think about INA 245K, that sort of thing, they can issue an RFE and ask about that. And those RFEs are one of the pretty major common types of adjustment RFEs saying, hey, show us your employment authorization, from date X to date Y. And so that's something they can come up. They can ask you, and well, you're going to be required to explain yourself if you have, if you have work authorization.
Yeah. So we answered the question, and we also answered the question, does it really matter? And we said no, it doesn't matter. So we got a couple questions that came here on the 6 o'clock. Brian, why don't you tackle the first one?
Yeah. So here's the first one from Parth. What happens if your green card EAD extension does not get approved by the time your 540 days of automatic extension period is over? Pretty simple. You must stop working. 540 days is a long time. 540 days, what is that, a year and a half?
Yeah.
I mean, I really hope that USCIS isn't, that nobody's really running up against that time frame. I know the EAD processing times are pretty weak, but I think they're usually a little bit better than that. Fundamentally, always recommend people to file their extensions as early as possible. So if you file your extension 180 days out, and then you have the benefit of a 540-day extension, you have you're giving them 2 years to approve your EAD. And if they, honestly, if you're running up against that 540-day deadline, I think, what happens? I think you talk to somebody like, you or me, and we say, contact your congressperson, for example.
I wouldn't wait for 500 days. I would wait at day number 250.
Yeah.
Or maybe 300.
Yeah.
That's 10 months.
Time to act upon this problem, I guess, is your point, right?
In the U.S. government, the squeaky wheel. What happened to the squeaky wheel, Brian?
Gets greased.
Gets greased, meaning that the louder you are, the more noise you make in a professional way, there will be attention given to your concern. So you just need to be proactive and not worry about contacting congressmen, having your attorney contact USCIS, write letters, do things highlighting.
Yeah, and ultimately, you can sue the government if they are taking, a ridiculous amount of time. You can do a mandamus action.
If necessary.
Yeah, if necessary.
Yes.
And 540 days is a ridiculous amount of time. They should be able to prove it. EAD and that.
Yeah. And Nitin has a question.
Nitin does, but I think Parth has a couple follow-up questions here.
Let's do it.
So, do you need to file Supplement J if you change employers on green card EAD? So, the answer to that question is maybe. It depends upon what, in my book anyway, is maybe, but it depends upon what your intent is. Take the time and read. Everybody should do it if you're going to sign it, of course. Read Supplement J and read what it says you're signing off on. Basically, Supplement J says the employer is offering this job on a permanent basis, and the employee is intending to take this job on a permanent basis. So, if you are intending to change your intended permanent employer by changing employers while you have a green card EAD, Supplement J is going to be required sooner or later. If your plan is to just tell your green card sponsor, guys, I'll be back in 3 months. Keep my offer of employment open for me, and they're want to do that. Not necessary. Or if you're doing side work, for example, that employer doesn't require a Supplement J. A Supplement J is required from whoever is making you that offer of permanent employment in the United States.
Right. I was going to add that if the job is temporary, a Supplement J is inappropriate, and if the job is not a same or similar job to your green card application, Supplement J is not appropriate. And also supplement J is not appropriate if this employer is not the intended employer whom you're going to be working or for whom you're going to be working to continue to pursue your green card plans in the U.S. Let's assume you are a cybersecurity guy and you just decided to take a side job teaching because you love to teach and you're good in math and science, and you took a side job teaching in a university as you were looking for a cybersecurity job. The teaching position not likely to be same or similar job classification, and therefore that would not be appropriate for a supplement J, and especially if that teaching job is not a permanent job. So supplement J has certain requirements. It has to be permanent, as Brian stated. It has to be same or similar job classification.
Yeah, same and similar. Yeah, that's a very important point.
Yeah.
There's a couple more here. So if I move from H1 to green card EAD, can I take a break from work? And bottom line is if we're going to read the supplement J, the requirements of green card application in the United States, you're required to take that green card job when that green card is approved and in your hands. So in theory, you can take a break. However, it's not an idea that I personally love, because at any time that RFE can come in and say, we need a supplement J from you. Suddenly you have a ticking clock on your head to get a new job, a new supplement J into USCIS.
Well, ticking clock on the head would be a scary thing. However, I would want to ask, how long of a break? You 100% entitled to take a week or two off.
Yeah.
All right, you talked me into 3 weeks. But once you cross that, you're discontinued your employment in the U.S. and your green card is based on your employment. Now, there are circumstances in which a break is appropriate. One of them is sickness, health-related issues, attending to a family member who's sick. So there is a legitimate reason for the disruption of employment. And needs to be documented and explained, and you need to be able to join back. The green card is based on the government and the employer in the U.S. needs to fill a job vacancy that is not available. It's an employment-based green card. So you cannot walk away from employment on any extended basis. It just defies logic, in my opinion.
Yeah, I mean, fundamentally, even though if you can say, no, my employer is willing to take me back as soon as I get that green card, I think the government, what you're saying is, can start questioning. So you're telling me you've been, sitting on your rear end at home for the last, 9 months, and you still have an offer of permanent employment in the United States? I mean, it's something that could in theory be overcome, but it's not a scenario I love. I mean, I would worry about, even that, taking care of somebody example. Well, so you left your job in order to take care of somebody. Well, is that obligation going to continue after we give you a green card?
Can you get somebody else to hire somebody as their caretaker? You could have hired.
Yeah, I mean, fundamentally, you have to make the government believe that I'm taking that employment-based green card and you follow through on it.
Yeah, when you take off for, you have to be able to show that you had no other option. Brian, your mic is off.
Oh dear.
Yeah. So you guys are enjoying Brian off of my mic. So
I like to think
I'm going to send you the bill for that. Is your mic on?
I like to think that my voice is loud enough to carry for a microphone even across the room.
I know.
Yeah.
I know. Well, Brian was so happy with his tie as the American flag, he didn't even want a microphone on it.
No, I didn't want anything to tarnish the stars and stripes that I have on here. Sam, I still have more questions in my hand.
Yes, sir.
So this is sort of the final one from Parth. Can I do business and not work in an IT field? This is coming off the idea of when you do a supplement J. I think you answered it pretty well earlier. Essentially, side work doesn't have to be related, but your supplement J intended permanent position must be in the same or similar occupation, right?
Yes. So everybody understand what we're doing today. We've decided not to go into a substantive topic, and we need your feedback, by the way, if you guys like that. And we have promised to answer every question that comes in today. So we're not leaving today until all questions are answered, or legitimate questions are answered.
Yeah.
So
I'll take softballs. Why are you guys so great? Things like that.
Yeah, I mean, related to immigration law, I'm not going to take. We're not going to answer questions about
Yeah.
You know,
Yeah.
But yes, all questions. So put your questions in. We're not going to leave today until we answer all your questions. We're going to just experiment with that and see if that's something that appeals to you guys in terms of a change up. Maybe we'll do this once a month. And if you guys don't like it at all, we will just go back to the original format. Brian.
I have one more question in my hands here from Nitin. So employer 1 applied for GC and EB2 in 2012. Downgraded to EB3 in October 2020, changed to Employer 2 under AC21. Employer 2 filed for I-45J, which was approved. Changed to Employer 3 in April of 2022. Employer 3 did not file I-45J. Got my green card in December 2022. So this is after he had moved to this employer that never filed a Supplement J. Will there be any issues since Employer 3 did not file I-45J?
Yeah. There is a potential problem.
I kind of agree. You know, go ahead, Sam. I'm sorry.
No, well, I mean, obviously, the approval came at the date in which your offer of permanent employment ceased to exist, and therefore, that green card is very much vulnerable, in my opinion, to being challenged later on if that discrepancy between the termination of employment is discovered in the future. Now, how likely is it to be discovered? I'd say not super likely, but it is definitely a big concern for that green card that you have in hand. Now, how do you cure it, Brian? And we're not giving you an advice how to cure it because you really need to consult with a competent attorney, but we're talking in general. How would you cure a situation like this in general?
I'm not sure I have a great answer to that question off the top of my head. I don't consider it to necessarily be
curable.
Curable. I mean,
I would suggest.
Okay.
I would suggest to go back to that employer.
Okay.
And revive that permanent employment.
Yeah. Essentially saying
for a reasonable period of time.
I've got to there. I understand that one. Yeah.
That might not save the day, but might give you an argument or might dissuade the government once discovered for them to take any action.
Yeah, I could see that. I mean, I guess I would emphasize what the problem is really. You know, when you submitted that Supplement J to change to Employer 2, you said, yes, guys, heads up, this is the offer of employment I'm intending to take on a permanent basis. And then, you know, evidently, you know, you had a different one and you didn't notify them about that. Now, there's people out there who will say, you know, they issued you a green card, the green card's in your hand, you're done, you can go do whatever you want. Next day, you can leave the employer.
But he left the employer before you got the green card.
Yeah.
That's even, it's crazy.
Yeah.
I mean, it's a serious concern. It's a serious concern.
Yeah, I mean, do you think it's likely to come up? Like you said.
The likelihood of it's coming up is a question of, do you think next month the visa bulletin is going to give this? It's a prediction.
Yeah.
It is not a something that we as lawyers. I mean,
well, yeah.
I can answer the question.
All that matters if it does, you know, and if it does.
Here's the example, and I like metaphors, right? Yeah. You answered 5 + 3, and you put 12 on an exam, and you got 100% on the test. Now, test is over, you got 100%. Now, is it possible that the teacher is going to find out that you answered incorrectly and they're going to deduct points in the future? Yeah. What's the likelihood? Probably not.
Yeah.
But did you answer correctly? No.
Yeah.
Did you deserve the 100? No.
Yeah.
Did you deserve the green card? No. Do you have a green card in your hand? Yes. Are you a permanent resident today? Absolutely. Can you lose it tomorrow? Absolutely. That's the answer.
Yeah. I think.
What's the likelihood?
I don't think I haven't heard of USCIS going back to revisit the scenario, but they have in the past surprised us by revisiting things.
No, I disagree.
Yeah,
I disagree. Number one, we have had situation where the USCIS came back and said we gave you the green card by mistake.
Oh yeah, okay, I do. Yeah, okay. I do agree with that.
And also, the Trump administration spent a lot of money digging into the naturalization of a lot of people, and they spend a lot of the filing fee money, that's why we get in trouble. A lot of the filing fee money, investigating naturalization approvals, trying to overturn them for people who came across the border and did not inform USCIS during the second application that they were deported before. So that he was hunting for those people.
Yeah.
He spent a lot of time and money trying to catch, and he caught some of them, but very few, but spent a lot of money doing it. But yeah,
in theory, it's possible they can develop it.
Crazy stuff
I do
happens.
agree
Yeah.
that. I mean, I'm 100% agree that it's possible they could, in theory, develop an interest in this, and all it takes is a change in policy at the top.
Yes.
So
moving on, Brian.
we have made it off this sheet of paper,
All right, fantastic.
and we're going to
Sriva.
to see what Sriva says.
Yeah. So Sriva, EB2 priority date is 2014, January 2014. The I-485 is pending, and the status changed to ready to schedule for interview. I have traveled, booked for India next month, 1 of 3. That sounds very familiar to a question I received through the web. It could be the same gentleman, I don't know. Should I reschedule? Well, you have a trip, he has a trip, and he doesn't, and I think my understanding, he does not want to disrupt his trip, cancel his trip.
Yeah.
And they asked for, and the priority is not current. He's not going to get a green card.
Well, yeah. So for the record, I mean, ready to schedule an interview is different from the status. Usually, the status they'll say is interview notice sent, and so they may have not actually scheduled an interview yet, for one thing. And typically, they issue these things about 4 to 6 weeks out. So depending upon how the what the plans for the travel are.
So why would they interview somebody like that? The right hand doesn't know what the left hand is doing.
Well, yeah. I mean, maybe they're trying to get a case that'll be ready to be approved as soon as the priority date is current. You know,
January 2014 EB2 is going to become current.
I can't say it's going to become. I mean, we have
Do
every.
you think they're predicting that?
I don't. So, no. I can't see how they could be, because the visa bulletin, final action dates for employment-based EB2 is in India as in October 2011. That's about
3 years.
3 years off. That's a long amount of time. But well, people always ask Sam, do they work on my case even though my priority date's not current? Case in point, Sriva here.
So, so what would you answer for a situation? Would you, if you had a case like this in the office, would you recommend scheduling an interview, rescheduling? Or canceling his trip?
There's been, fundamentally, the first question I would ask Sriva is, how long are you planning to be outside the United States? Because
I'm gonna make it easy for you. 2 months.
2 months. Mm-hmm. Have a friend pick up your mail because for you in your absence. And
would you reschedule the interview?
I don't know when the interview is. Sriva doesn't know where the interview is.
During this well, okay. So would he write him a letter, say I'm leaving the country? That's an excellent point, Brian.
If the plans are not changeable, if you have something important, it's possible.
Not likely he's going to get an interview notice. They're saying.
Yeah, I don't think it's even likely that Sriva is going to get an interview notice. But Sriva has some follow-up questions for us. 2
or 3. If reschedule, well, Brian said there's no schedule to reschedule, but let's assume you got one.
I don't believe anything the government says until it's in my hands. So,
I second that.
Yeah.
Let's assume it got rescheduled. Now he reschedules.
Yep.
So if reschedule, how many months further I can get another appointment?
Unknown.
Depends
upon the workload of the field office.
They can look at it and say, they may just discover that the priority date is not current and never schedule a second appointment.
Very, very, very possible. There's human beings on the other end. If they figure they can save themselves some time, why not? So anywhere from from immediately or until your priority date is current.
Will rescheduling cause any harm to my green card application?
Generally, no. I'll tell you Sam, the problem with rescheduling is they tell you to call USCIS to reschedule, and basically they don't tell you immediately whether or not they've approved the request. For example, I had somebody who came to me and said, "Hey, I had this green card interview, and I'm going to be out of town. We're going to Hawaii then, and I can't be there for the interview." And we called you. Don't worry about it. Well, we called USCIS to take care of it. And so, well, did they say it's a did they reschedule it, or they say they're going to consider the request? And what stresses me out is if they can deny a reschedule request. It is discretionary. And I very much worry about, taking for granted that they're going to approve this reschedule request, and then, you're not showing that there in the date of, and then suddenly, it causes problems. So an actual bona fide reschedule where USCIS has said, sure thing. No, they're understanding, but yeah.
All right. So for those who just joined us, we're taking questions today, and we're answering all questions before we terminate, how long that takes. So we'll go on to the next one here from Yes Van.
Yeah.
How does I-9 work? I am planning to change employer and use EAD. Okay, so I-9, very simply, is not a document that you as an employee should be concerned about. It is a document that the employer is required to complete and maintain, and there's no consequence to you if the I-9 is not done at all or is not done properly, as long as you're authorized to work in the U.S. But how does it work? In simple terms, there are 3 parts to the I-9, Part 1, Part 2, and Part 3. Part 1, you complete with your hand. You fill your name and your work authorization source. Are you a permanent resident? Are you a U.S. citizen? Or do you have an employment authorization? You just complete that Part 1. Part 2 is the employer complete, which they receive documents from you evidencing identity and work authorization, and they complete it. And then Part 3 is the sworn statement that they have confirmed that you're authorized to work in the United States, and they enter dates in which they conducted the authorization, which is typically within 3 days of employment. That's how it works.
Very concise answer, yeah.
All right, let's take the next one.
From Bargov. I'm on F1 visa working on STEM OPT until June of 2024. Can I travel and get H4 visa stamped and re-enter on F1 visa? Well, that's entirely possible.
So you go into the consulate and you get an H4 visa stamped.
Yeah.
You're risking for them to cancel your F1.
Great point, yeah.
Sometimes they do it. They shouldn't. But if you got both, you can choose which of the two you will use based on whether or not you have a valid I-20, and then you re-enter on your I-20 with your EAD card, showing your EAD, STEM OPT, and employment. You may need to show employment, and you're fine.
Yeah, I mean, I guess I would say is that H-4 visa doesn't do anything for you if you enter the United States on a student visa, aside from maybe...
I like the H-4 visa because it gives him alternative options.
Yeah.
So, for example, let's assume that he had problem being admitted on F1.
Sure.
So he can go on H4. Now, once you're in the U.S. on an F1, you cannot switch to H4 unless you leave and re-enter, which also gives...
That's the point I was making.
But that's a good option because let's say he got laid off.
Yeah, the F1...
And he doesn't want to be out of status.
Yeah.
So he can go to Mexico and come back on H4 and then...
Fully agree with that.
Join employment whenever he wants.
I am all for having multiple visas. Fantastic. It's just a big brain thought was really that they can cancel another visa.
And it's a lot of trouble to get the H4. But yeah, I mean, in my opinion, the H4 EAD is superior to the F1.
Well, that H4, yes, but that EAD is going to take, ask the people out in the audience, that EAD is going to take a long time to get, for sure.
Yeah. But now, with the renewal, you can file the H4 and the EAD at the same time. They should act on both of them.
Yeah, this is very true.
So we have another one.
Yeah, from Parth. In what circumstances can green card EAD renewal application be denied? I really can't. I mean, in my mind, the fundamental requirement for a green card EAD is that you have a pending green card, right?
So we're seeing denials when you're asking for 2 of them.
That's which is something I don't think they should be doing.
Yeah. Yes, correct. So we're seeing that, and they should not be doing that, but they're doing it.
Well, I want to elaborate it for people who don't know. Occasionally, there's people out there who have multiple pending adjustments of status cases, right? And if you file, for EAD based upon your EB3, you get that in your hand, and you submit another one to get what based upon the EB2. We have seen decisions where USCIS says, no, you already have an EAD. No thanks. We're not going to approve this case. Yeah.
You can get it denied by error in the application.
A well-submitted case, it's highly likely to be approved. I'm not losing sleep over green card EAD renewals, that's for sure.
I agree. Silver Gem, finally green card after 295 days. Yay, give him a clap.
We got a button for that.
Yeah. All right. Wow, and congratulations. Interview was January 12th, card produced on January 24th, and delivered on February 3rd, EB2. Silver Gem, congratulations. Very happy for you.
Yeah.
Great news.
Yeah, it gives people a good idea anecdotally as to how long it takes to get that green card from interview
Let's
into hand.
repost those dates one more time.
Yeah, so interview on January 12th and, card produced on January 24th and, mail it in your hands. It's funny, I don't know when they approved Silver Gem's green card. I've been, literally in the parking lot at the USCIS, field office talking to a client. It's,
Right after an interview.
Yeah, and they go, I got a notification on the phone, but sometimes it just depends upon the officer and the circumstances. Sometimes it can be a while before you actually get that approval.
Yep. All right. So Kulkarni.
So Nitin, who asked one of those early questions that we had here, I believe.
Okay.
Yeah. Employer 1 applied for a green card in EB2 in 2012, downgraded to EB3 in October 2020, changed to employer 2 under AC 21. So he's really, I think he's just sort of giving us the facts, which we sort of presume there from what we heard.
Got it. Okay, wonderful. Bati Varun. Sam Bryan, first, thank you for a ton for doing these sessions. You're very welcome. Do we have restrictions on how many full-time, part-time jobs can we do on green card EAD? I like the baby's picture, very cute. There are no limitations as long as you have one full-time green card EAD that is considered your supplement J job.
Yeah.
And then you can do as many of those as you want. It doesn't matter as long as you have 40 hours or 35 hours full-time dedicated to the supplement J job, if you will. Would that be a good answer, Brian? Or
I think that green card EAD is unlimited, but ultimately you have to have that full-time permanent job. And as we discussed earlier in this, your smart money is stay with that full-time permanent employer, because if you drift away from them, the government can say, really? You were working for 12 other companies, but you're going to be joining this one on a permanent basis? Yeah.
So Bhargav wants further clarification. Can I have both F1 visa stamp and H4 stamp on my passport? The answer is yes. If I got H4 stamping, will the consulate cancel my current F1 visa before they give the H4 visa? They shouldn't. You may want to tell them that I really don't want it canceled. But yeah, it's their discretion. Really.
I think there's a reason Bhargav's asking that question, and we're worried about the same thing. So they will do what you they're nice folks, usually nice folks there. I think they will listen to what you say, but yeah.
Yeah. So Kulkarni, I don't know if we answered that part of the question.
Yeah.
It's
just a repeat of the facts, I think.
Okay.
Yeah.
So sky limit, can a conditional green card time period be used for naturalization after condition have been removed? Yes.
Yes.
Wow, you did not answer correctly.
Same time. That's it.
Yes.
I'm going to think about the marriage-based, green cards. Oftentimes, the I-751 removal conditions for those marriage-based green cards, the processing times are brutal right now. And basically, one way to sort of people accelerate the process is while waiting for the I-751 to be approved, they basically file for naturalization. And we've had plenty of examples where people go for a naturalization interview and they essentially adjudicate the I-751 at the same time and say removal conditions and also you're a U.S. citizen.
See you later.
Congratulations.
And now they're giving 48 months extension.
Is it up to 48 months now?
Yeah.
Jeez, that's insane.
That's crazy, yeah.
Yeah.
So Amarnath, hello, my off
I'm gonna presume that means PD. I think. Yeah. In fact, those letters are right next to P and D on the keyboard here.
Okay.
So.
Good, Brian. I'll let you handle it.
I missed my chance last year because my perm had been done again for the promotion I received. Expect a new perm to be approved. Should I apply in EB2 or EB3? I think I have a good answer for this. Why not both? There's nothing that prevents you, as long as your perm qualifies for the EB2 category, it will qualify for the EB3 category. You can file in both categories. I think,
the answer.
Yeah.
Again, for everybody to understand, we're trying to answer every question that comes in here and see if you can beat you guys and answer all of them. If it goes beyond 7 o'clock, today we're answering every question that comes in. All right. Yes, Van. Prior dated December 2013, both I-140, EB2, and 3 are approved. Interfiled to EB2, I-45 Supplement J pending. Any prediction on EB2 or 3 as we are heading into quarter 3 or quarter 4, Brian? And the prior date is December 2013.
Well, basically, every time a new quarter begins, that's when we think it's most likely to see movement. The next one begins in April. Look in April. I am still hopeful that we'll see some, gentle movement forward in dates rather than the painful backwards movement that we're seeing. But, we'll see.
December 2013, filing dates at least. Well, I mean, he doesn't care about filing dates. I-140 is approved, and he's talking about the interfiled supplement J. So he has I-45s already.
Yeah.
So he cares about final action date only.
Yeah.
So right now they're June 2012. For India, for EB3, and October 2011 for EB2, and it's a big jump.
Yeah,
I don't see that jump from what we've been seeing to occur.
Well,
at least in the third quarter. I don't know.
So
about the fourth
I don't
quarter.
like making predictions of the visa bulletin, but in the past I've gone back and looked and see what the visa bulletin does. Sometimes when they go back a whole lot, it facilitates forward movement over the next fiscal year. But then again, we haven't seen much forward movement in this fiscal year.
Which means maybe there will be forward movement.
Yeah,
and then the counter argument: if they move back that much, how can they move forward?
Yeah.
So it's a total guess.
Yeah.
All right, Sriva.
Yeah.
Downgraded EB3. Okay, I-45 pending. If EB2 denied, will still in status work on EB3 EAD and address EB2 denial being legally in the U.S., or do I have to leave no H-1B active? So if you downgraded the EB3 and I-140 if we're pending, I would be curious first to see if he has a second EB2 unrelated. So because I'm not clear here, unless you read it differently, Brian.
No, I think this is a situation where there's not enough information for me. And maybe this is a situation with two I-485s in process. I'm not.
So let's answer on both ways.
Sure.
And then we move on. So if there's only one I-485 and you've moved it from EB2 to EB3, you got one I-45. It's denied. You're done. You have to leave.
Yeah.
And then fight it outside the country. Really, there's no option for you. Now, if you have two I-485,
you can always appeal an I-45 denial.
Right, but you are accruing unlawful presence.
Yes, sure.
And there's complications.
Yeah.
And that's always we've been talking about having this dual I-485. The beauty of dual I-485 is the denial of one makes you fine. You just continue living here and working here, and that's why I don't agree with them denying adjustment of EADs.
Yeah, because if they say, hey, we denied this I-45 and we're also denying your EAD and AP, well, what about my other I-45?
But the argument would be that the EAD, they've already declared that the EAD can jump to the other one.
Yeah.
But that's not something that we're talking about, but that's something to consider.
Something for us to hope that scenario never happens to anybody, and that we have to we really
So if you have two
one.
I-485, one is denied, you stay in the country. If you have one I-485 and denied, you must leave.
Yeah.
So that's the answer. Brian.
So from Bargab, F1.
I think we answered that
I think we did.
Yeah.
I would say just remember, everybody, what the format is for tonight. We've already crossed the half-hour mark, so this is when we normally do Q&A. Anyway, but we're going to try to answer all the questions we get here regardless, so there shouldn't be a need to repeat them.
And we'll be back in a second. All right, guys. Just a reminder, we're doing a Q&A all day today, answering everybody's question. And the promise is we are not leaving until we answer everybody's question. We have spent half an hour. We've probably answered about 15 to 20 questions. And we're moving on.
Keep on going. I'm gonna pick up the pace a bit.
Yes.
So, Srivan Kumar Vanaparthi. I'm also planning to visit India in June. If I've applied EAD, AP and EAD, should I apply before travel or after return to the USA? So, general rule of thumb is they won't consider an EAD application abandoned if you travel, but they've been known to change policies in the past. But if this is your first AP, for example, if you don't have a valid AP, they will deny an AP while you're traveling. Is the bottom line from me. So I would love to see you have a fresh AP in hand.
Yes.
I wouldn't want to be using my AP on its last day and then have my flight get canceled or something like that.
Absolutely, I agree. Yeah. Steve, I have a question. If they deny an I-45, how do they do it? What do they do? Well, there are 3 methods to deny an I-45. As you stated, there is a notice of intent to deny. There is an RFE and then a decision, and then there is an extremely rare but absolutely is there, and I have seen it, an outright denial.
Yeah, me too. I've seen them.
Yeah, which is like ridiculous.
Yeah.
Ridiculous, but I've seen it. How do you? As a matter of fact, when you have a denial without any opportunity to rebut, you really have a great foundation to rebut.
Yeah, I mean, I guess how do you address? You appeal, right? And one of the first things I'll tell them is, guys, there was, you rack your brain for all the reasons why they could have, not denied this I-45, all the legal options to keep this case going, and remind them, well, you didn't send me, you didn't ask me for a supplement J, you didn't consider law X, you didn't consider law Y, you didn't consider your own policy. Yeah, you could appeal it.
We've had a gentleman that came to us who had a denied I-485, I believe, without he got an RFE, or I think he didn't get an RFE, he just got denied.
Yeah, after an interview, he just got denied his
No,
I-485.
I think they got confused. They denied him, and then his other attorney filed for a motion to reconsider, and the motion to reconsider was denied, came to us. We filed a second motion to reconsider because we were within that period and we were able to overcome it. So you can also, there's a lot you can do.
Yeah, when I say appeal, I mean motion to reconsider on a...
Yeah, so there's a lot of options available for you. But if you're concerned about a denial, let me talk about the elephant in the room. Because we're talking about the China, the small China, but we're not talking about the bull in the room.
I don't know if I
the
like this
elephant in the
metaphor.
room.
Okay, continue.
If you're concerned about denial, talk about it now with an attorney. Don't wait for them. So if you have a concern about something in your application that's causing you to worry about it, don't wait. Yeah. Talk to an attorney because you could preemptively fix it or preemptively prepare for it. Do not react, anticipate, and take action. That's how you win.
Yeah.
Any comments on this?
No, I fully agree. If you think you have an issue coming up, you have all the time in the world. If you have a RFE or NOID or even worse, denial, you have limited time to address these things.
All right, Parth, can you travel out of the country if your advanced parole extension application is still in process?
Now, USCIS policy, as it is currently right now, is that they will not deny a pending extension if you have a valid advance parole.
So number one, I'm assuming there's a pending adjustment.
Yes.
And number two, I'm assuming you're leaving the country pursuant to a valid H-1B because you can come back, you're not abandoning your adjustment of status, or you had another advanced parole approved.
Yes.
Now, if this is a first advanced parole, Brian, would that be considered abandoned?
Yes. Yeah,
So-
see, I'm reading it says advanced parole extension, so I'm presuming.
Okay, and he had a prior extension.
Yes.
Okay,
yeah.
good assumption.
Sam, I think Theo, we should interrupt and just remind everybody. We are answering these questions in a general way in this venue.
Yes, we do not know the case. We do not know who you really are. We only answer questions based on a single line, and we give a general answer. Always consult with an attorney of your choice before you make a decision on your case, or take action on your case, or travel, or whatever, because we really do not know all the facts. Because here we're trying to fill the gap with some of the stuff.
Yeah. I usually will say, what the general rule is, but it's hard to figure out your specific details. Yeah.
Mr. Bott says, hello, Sam and Brian. Hello, Mr.
Hello.
Bott. Ajith Suda, I have an EAD advanced parole card. Recently, my H-1B extension got approved till 2025. I need to travel. If I use the advanced parole at the port of entry, how can I keep my H-1B status after that with approved H-1B?
Well, when you enter using an advanced parole document, you enter as a parolee. You are not going to be on H-1B status anymore. It may be possible to resume H-1B by filing, assuming you're coming back to the same employer. It may be possible to resume your H-1B after that. There's a policy that may allow for that, depending on your exact travel circumstances.
Right, but the policy states that if you join your H-1B employer, you could be presumed.
Yeah, I'll go into. If you leave your H-1, if you leave the United States in valid H-1B status with a particular employer, and you come back on advanced parole and you rejoin that particular employer, you should be able to extend your H-1B status through an H-1B filing when you come back to the United States.
Yes. Shika 119.
Yeah.
Not 120, 119.
Okay.
Very serious. Hello, good evening. Can we travel while advanced parole renewal is pending, or will it abandon the renewal? So pending, renewal. General answer, Brian.
General answer is your first AP. If you travel while it is pending, they will deny it. If you have a valid AP and you file an extension and you travel during the pendency of your valid advanced parole, they should not deny an extension. That's their current policy. But I would caution people. They changed that policy in the past and without telling people. People traveled pursuant to their H-1B visas, for example, with a pending AP. And they denied those APs, and people were surprised by that.
So I got a question here from Mr. Bott, that says, how can I identify where to send my I-765 and I-131 renewal? There are multiple pages with different lockboxes. Confused. It is confusing. We spend a lot of time identifying these locations. It requires really a knowledge and a skill in doing that. How to do it is obviously we do it every day, and we know how to read those.
Yeah, my answer to this question is I look at the website.
We read everything from corner to corner, sometimes multiple pages, and sometimes more than one person to confirm addresses.
Yeah,
it's a big deal. It's a big part of what we do. It's hard to tell you how to do it. It's almost like how to fly a plane. You cannot explain it on YouTube how to fly a plane.
Yeah, based upon it's fact sensitive, unfortunately. Yeah.
Yes. KK, Brian.
So I am planning to work in India for a year. Can my H-4 dependents continue to live and work in the U.S. using H-4 EAD? How long can they stay? Can H-4 stay and work in the U.S.? An interesting question, Sam.
Great question.
And I think the answer has to lay somewhere in the gray area. I want to, the bottom line is, if you're intending to work in the United States, in India for a year, you're not an H-1B worker in the United States anymore.
So congratulations, you have entered the gray zone.
Yeah.
Do you want to give him a congratulations button?
I don't know. I'm going to give a clap. I don't know if clap is the right answer.
Well, we have other options to clap. I mean, what do you have here?
I don't know. We have this button here that says labeled magic, and I think the gray zone is probably a very magical place. So I'm gonna.
Okay, whatever that place.
Yes.
All right. So number one, I would answer what I would like to know is when you're going to India, are you still working for your H-1B employer abroad? And I also would like to know whether that employer has confirmed the continued offer of employment and the continued H-1B status, and the need for you to be abroad is a business necessity, not for your convenience. Once these things fall apart and you're not answering yes to my questions, I start to become slightly nervous about whether or not your spouse on H-4 EAD is legitimate here in the U.S. It's one of those things that how does USCIS know? Question. If you're leaving back home because you want to take a different job or you want to go on vacation or you want to go to for religious reasons, completely unrelated to your employment, I would be concerned that that H-4 dependent status is not proper and it's on slippery slope, both the H-4 status and potentially the green card application.
I mean, for me, the question I want to ask is, where is your work? You know, if your work is not in the United States, you're no longer an H-1B worker in my book. Now, obviously, it's possible to be an H-1B worker in the United States, you know, hey, we want to send you on a business trip for meetings in Canada for a week. That's not going to bother me. Your employment still lies in the United States. But if you're telling me your employment, you know, lies outside of the United States, in this scenario, it seems like it does, I say as soon as, you know, you're employed outside the United States, you are not an H-1B worker. So maybe it's a little bit less gray than I thought, but it's not a scenario where anybody's going to tell you.
Well, it's a great. So here's the bottom line, guys. You guys are techies, most of you. Not all of you, most of you. You work in the world of either the outcome is correct or incorrect. We, as lawyers, work in the world of gray, shades of gray. Our black and white is very narrow.
Yeah.
We are in a situation where we say you are in the dark gray, you're in the light gray, and that's where you're at. You are right there in the zone of the facts will dictate, not enough information to give you a solid answer.
Yeah.
Bhavesh, can I ask USCIS to adjudicate derivative green card in the EB3 category now?
Well, I suspect this might be something where part of the question got cut off. I'm imagining something where I got my green card, and I'm gonna maybe scroll through here, see if they came in out of order. I don't see.
Here you go.
No, it's from somebody else.
Yeah.
So basically, when you are entitled, I think we're just gonna have to move on from this one, Sam.
So the answer is not enough information.
Yeah.
To help you out.
Yeah.
But you cannot ask USCIS to do something. They do it when they're ready to do it. The only thing you can do is you can file and pay your fee and wait for your line. Yeah. If you are approved, if your green card is approved and your dependent is not approved, you can probably put pressure on them by multiple means, but you cannot request that they do it. But if you want to ask them to do it now, there is something called writ of mandamus in courts, a court action that you can file. And writ of mandamus, it's nothing, it's Latin that says, let the government do their job.
Yeah.
Ask the judge to compel the government to do their job. Yeah. And that's a court action.
Yeah, so the fundamental question that we don't know, the fundamental facts we don't know are why they haven't approved a derivative right now. So
Noor says, PERM was filed with job requirements for EB2 in mind. Would it be possible to file under EB3 when filing I-140 at the time of porting the old priority date?
Yes. So generally speaking, the requirements for any EB2 job, the EB2 perm is available for people generally having a master's degree or above, right? Or a bachelor's degree in 5 years of post-graduation progressively responsible experience. Those requirements are guaranteed to meet the EB3 requirements as well. And that's really it, unless you're doing an exceptional ability EB2, but I presume that's outside the scope of this. Yeah.
Yes. All right. KK I moved to the US in 2014. Before that, I worked for the same employer in India. Can I upgrade from EB2 to EB1 as I work as an executive manager in India? The answer is absolutely yes. It can be done. You can do an EB1 multinational manager or executive green card application, and should be able to do it successfully if you have the evidence to support it.
Well, yeah, I would say that your proposed role in the United States must be that of a manager or executive as well. It's just not that you worked for them in a managerial / executive capacity abroad. You have to be offering U.S. management / executive position too.
Vijay Singh, do you see priority date April 2013 EB2 or EB3 getting current in 2023? Well, it's EB3 June 12 right now.
Yeah.
So, I mean, do I see it in 2023? Potentially, but it's very difficult.
Yeah, I don't think it's so crazy. But again, wait for the next visa bulletin in April. We're going to see what USCIS is seeing in terms of their visa usage in cases coming in.
Does H1B, H4, and H4 EAD get approved in 15 days if applied together based on current settlement? Did you see these approvals recently? Well, the current settlement is a week old.
Yeah.
And they're supposed to be approved if they're done in premium processing.
Yeah, and so 15 days premium processing, exactly.
Yes.
Yeah.
We haven't started seeing them coming in.
I think I've seen a couple. I mean, in more recent times, the last couple of months, and maybe this is like the USCIS.
But the settlement is a week old only.
Yeah, so the settlement's only a week old. In more recent times, we've been seeing a little bit more of it just happening what we thought was organically. Maybe there was them thinking about this settlement, you know?
Yeah. Can I appear in an adjustment status interview, that's from Sriva, with a different employer, I-485 Supplement J, whom I joined a few weeks before the interview? Yes, you can.
Yeah.
Will there be any issue? Can that delay green card since office did not know about the employer? The answer is it shouldn't, pending the intelligence of the interviewer and the correctness of your documentation. I would bring an attorney with me to the interview in a case like this.
Yeah.
Brian.
So hello from Animesh. I've read many folks are getting green card even if their priority dates are not current. Is there any risk to use that green card? Any reason why these folks are getting green cards even when the priority date is not current? So when you get a green card, you kind of have to presume that the government has issued it properly. But I would be concerned with one, and it's maybe possible to inquire with the government as to whether a green card has been issued properly. Because we have seen USCIS issue green cards to people just by oops error, and it is very possible for them, if they later find out that the green card is issued in error, to come back after them. So I think it's possible to investigate these things. I think it's reasonable to rely upon the green card you have in your hands, but I think it's potentially wise to investigate further in that if you don't think you're entitled to it. You know?
It's also possible that the visa number was pulled for you, and you had a visa number in the file before it retrogressed, and then they opened the file and say, "Oh, we pulled a number for him. Yeah, let's use it."
Yeah.
So that's a possibility as well.
Yeah.
Suresh, is Biden administration coming up with any reform for EB immigrants for backlog countries and for documented dreamers? Well, right now we're into a divided government, meaning that the Congress is split Democratic and Republican, or is it all Republican?
No, the Democrats get the Senate, and the Republicans have control of the House by a narrow margin. And I don't know. So I'm sure if you ask President Biden, he has several ideas in order to fix that issue. But the bottom line is it has to make it through Congress. The big stopping point in Congress seems to be the perpetual impasse over what to do about, Republicans want something over border security, Democrats want something to help the undocumented dreamers sort. And coming up with a compromise on that seems to be the real impasse.
So it's possible, not likely.
Yeah.
Noor. 1 of 1.
Yeah.
Okay. H4 was filed and later sent a withdrawal later while H4 was still pending. It's been more than 2 months and still online status showing case received. How long it takes to withdraw by USCIS? 2 months is a long time, but everything is taking forever.
Yeah, USCIS. I have literally encountered the occasional scenario where literally like a year before they actually acknowledge a withdrawal is the bottom line. Yeah.
Part 2, after a month of withdrawal letter sent, filed new H4, received receipt notice, what would happen when the officer looks at both pending petition, assuming previously filed H4 is still pending? Well, they can probably withdraw, acknowledge the withdrawal as they're processing, or issue an RFE inquiring, in which case you explain.
Yeah, I mean, to give you an insight, Noor, when we draft a withdrawal letter for one of our clients, we try to be very specific as to what we're withdrawing because we don't want them withdrawing anything else accidentally.
Yeah.
You know?
All right. Sam Fax, do I need to be currently employed to be able to apply for EAD AP extension? There is not a requirement to be currently employed, but to be currently employed is a requirement for the green card, obviously, application. They don't usually inquire into that, but there's no guarantee that they would not issue an RFE if there's a suspicion.
Yeah.
But there's not a requirement, nor is there a question, or I've never seen an RFE in that regard.
No, I mean, again, like I said earlier, I don't lose sleep over green card EAD AP extensions.
Fine.
So from SK, hi, I have pending EB1B 45 petition past 180 days with approved I-140 priority date retrogressed. I am laid off while dependent traveling abroad with advanced parole. Could she face problems during re-entry? No, I wouldn't anticipate that is the bottom line. Would you, Sam?
Yes.
Yeah. I mean, okay. Here, I'll the other side of the question. The customs folks can cause trouble if they want to, but they shouldn't have noted. Your I-40, as long as your I-45 is pending, the AP should still be honored.
Yep.
Yeah.
I agree. Hari Guru, could you please explain when we consider a child is locked under the Child Status Protection Act? My kid is 45, is filed when final action date is current, I-140 approved below 21. Primary adjustment applied ahead of dependent. Kid applied based on final action date. Well, all the facts you're telling me in general point to the fact that most likely your son is locked under the Child Status Protection Act. However, the Child Status Protection Act is very facts-driven, Harry. And we are reluctant to say, yes, he's locked in, even though we see it, maybe, because we don't have all the facts of your case. What you really need to do, something we do in our office, other attorney may do it, I don't know, is we can issue a letter, a written opinion letter, whether your son is locked. A verbal statement from an attorney is really not worth the ink or the paper that's written on it, because a verbal statement doesn't really do what you need. You need a written opinion, and a written opinion requires a due diligence. So if you are concerned, there is obviously, typically these are not for free, but get an attorney of your choice to give you a written opinion as to whether or not your child is locked in, so you're not in a dilemma wondering. But all the indication to me, in general, lead me to believe that your son might be locked in, but I cannot go beyond that.
Yeah, I think that's a fair answer.
Brian, take that one.
So, from Parth, how likely one is allowed to be entered back to the U.S. on employment-based advanced parole? Do they always do secondary inspection at the airport? So, who's guaranteed to be allowed to enter the United States? This is something Sam taught me very early on in my immigration law career. U.S. citizens, and only if they have their passports in their hand. It's never a guarantee you're going to be admitted on advanced parole, but a very good chance if you have a pending employment-based green card and a valid advanced parole. Do they always do secondary inspection? Pretty darn good chance there will be.
Almost 100% of advanced parole are secondary inspection, because the officer has to confirm the authenticity of the document. Agree.
Yeah. From Raul, currently using EB3 EAD, but I also have one from EB2. Can I use them interchangeably, or should I stick with one category? I I don't know if I have any. I don't see the point of using them interchangeably.
I would put one in the drawer, using one consistently. I would not use them interchangeably, just to make your life easier, and treat one as a backup to the other one.
Yeah.
But you can choose them interchangeably if you want, but you're going to confuse yourself.
Yeah. I guess sure. Why would be my
keep one in the vault in a safe spot in the bank somewhere. And then use the other one, so you have one in case one is lost, or God forbid there's a problem with the one adjustment.
Yeah.
You can go to the next one. All right. From Santosh, Sahu 2K.
Santosh Sahu 2K.
Currently, I'm working for a company B. My previous employer, company A, filed my green card, and I got the EAD and advanced parole. Do I need to join back my previous employer? Well, you can either join back the previous employer, or you can supplement J to company B. If it's same or similar job classification, you might need to engage an attorney of your choice to advise you on a deeper dive into both options as we learn more fact, or as the attorney learn more.
Yeah, I think that's a fair answer.
Yeah, fine.
Can I travel from Santosh Sahu again? Can I travel outside of USA using AP without joining my previous employer? As long as your adjustment is pending and your advanced parole remains valid, you should be able to, travel using your AP. But fundamentally, you're going to want to be honest with the USCIS and send them a supplement J if necessary, like Sam said, to tell them who is actually going to be your permanent employer in the United States.
And have somebody check your mail for potential RFE.
Yes.
On this subject, and be prepared to come back to the U.S. right away. You don't want the RFE to be considered.
I guess we have, you didn't bring up Santosh, but basically, in order to take advantage of the portability rules, you must be able to meet those requirements, beyond 180 days of pending green card and be transferred to an employer with the same similar occupation.
Yep. Thank you for bringing up the 180 days.
Yeah.
Because we forget to bring it up sometime. CA, one of two. Hi, Brian and Sam. I am a German citizen born in India. Applied for adjustment status in June of 2022. Priority date August 2014. Approved in December. When requested FOIA, I found that I was charged under Germany. Correctly charged under Germany.
Oh, no, he said he was a German citizen born in India.
Oh, born in India.
I wonder if there was a spouse that was perhaps born in Germany.
Yeah, that's a good question. So what happened during renewal after 10 years? I'm not planning to apply for naturalization. So it looks like he got his green card in error. Is my green card invalid? Right there. So if your spouse is German, you were correctly
born in Germany,
born in Germany,
born any other country potentially.
You're correctly charged to a country other than India.
Well, let's we gave the explanation. Let's talk about what the rule is. There's something called cross-chargeability. If your spouse is born if you're born in India, as you say you are, and your spouse is born in another country, you're allowed to charge against the country in which your spouse was born. Yeah. Hi
Sam, Brian. While adjustment status is pending, is it okay to change the location, different state?
I think I have a good answer for that. I think it depends upon what your green card application says. If your green card, actually, I'm going to walk this back a little bit, but if your green card says, oh yeah, Sai is going to be working in, I don't know, Philadelphia, Pennsylvania, your green card, when you're ready for the green card, you're supposed to be working in Philadelphia, Pennsylvania. But if, your green card application says, oh, he could work in, Philadelphia, Pennsylvania, or various unanticipated locations around the country, it's possible for you to be living in a different state. However, ultimately, what that green card application says is that you're supposed to be working in whatever this green card application says upon receiving a green card. So fundamentally, it could be a situation where you might be required to go to a specific location when your green card is approved, depending upon what I said. The very first thing is what your green card application says.
Excellent summary. I'll add a couple of things.
Yeah.
When you're saying green card application, you're talking about the labor certification.
Yes, you're right, yeah.
And
labor, in the I-140, yeah.
Yeah, and the I-140.
Yeah.
Subsequent, yeah. The second thing is if you do supplement J, to a new employer, you can work anywhere in the U.S.
Yeah, if you meet the requirements to take advantage of portability, yeah, it doesn't matter if your original perm said only in Philadelphia, Pennsylvania. If you take a same or similar job in Los Angeles, California, Supplement J can allow that, and they shouldn't bat an eye at it.
Yes. Faraz, H4 was filed and later sent a withdrawal. I think we answered.
Yeah,
that
I think we did it, that one. There's the follow-up question which we answered as well.
Okay.
Yeah.
Marlon Wright, Brian. Take it.
Marlon Wright. My wife AOS from J1 to H1B, and I AOS from J2 to H4. EAD under J2, adjusted the status to H4. Can I get EAD extended, or will I have to start over? Well, starting over when I'd be eligible for EAD. So I think, as a clarification, I think Marlon, you're talking about change of status from J1 to H1B. Us immigration attorneys, and we talk about AOS, we talk about going from a temporary status like H1B or J1 to having a green card. But EADs are tied to their categories. Fundamentally, I think the question here is my J2 EAD good when I change to H4? The answer is no.
Thank you, Brian. Pakala Prasad. That's part 2. Did we miss part 1? Pakala Prasad.
Oh, we missed one.
Switching jobs, approved I-140 and pending 485. New employer has filed H-1B transfer and it is approved. The approval letter shall reach in a week or so. Company will file 485 supplement J as well. Any precautions to take still, or can I safely resign from my current company? Well, if so assuming 485 has been pending for over 180 days, and we cannot advise you because we give you general advice, and you should always follow the advice of your attorney. But however, as a general statement, so you understand, you appear to have an H-1B but not approved in hand, right? Yeah. I'd like to see an I-94 in my hand. Or I don't know if 180 days have passed, but you're doing great. You're in the right direction. If you get the I-94 in hand and it's beyond 180 days, and the employer is going to file a supplement J, and the job is same or similar job classification, and 15 other things that we haven't thought about, you're in great shape. Yeah. So yes, nothing jumps at me as alarming. Let's put it that way. But always consult with your lawyer so you can make the right decision.
From Sriku1, I'm on an L1B visa. If I cross the Canada border by road, can I recapture the days and extend my L1?
I don't think he understands how recapture work. Maybe he does and did not answer the question correctly.
I think what he's talking about is if I spend time outside of the United States, the way I read it is, I'm presuming he knows a little bit more than perhaps the explanation let's on. If I spend time outside of the United States, can I recapture that time in an L1, subsequent L1 filing?
Okay.
Yeah, and the answer is yes. You should be able to, for sure.
All right. He has a follow-up, right?
No, that's somebody else.
Thank you both. My cousin got his H-1B petition approved. Your cousin got to be on YouTube so we can answer his question.
Yeah.
We can answer the cousin. Okay, we'll answer the cousin question as well. Why not?
So
thank you. My cousin got his H-1B petition approved. Sorry, Brian. In October 2020. Went for stamping in February 2022. Got 221G and stuck there since. He never entered here. What are his options now? Is a lawsuit possible? A lawsuit is a very weak option for him. You really need to have, again, I'm sorry to say this, a holistic look at the case from an attorney can probably identify the zone within which that 221G occurred.
Yeah.
And then trying to file a new case, trying to avoid it. Is it related to you? Is it related to the employer? And what is it, and how can we avoid it, to be able to answer that question?
Yeah, I mean, I agree with you. I want to know what that 221G is about before I really...
I need to know what happened, what questions asked, how did you answer the questions. A lot I have to know to give you a good advice. this is very fact-driven. It's very difficult to answer.
Yeah, I mean, fundamentally, I'd say the consulates do have a lot of power to do whatever they want. It's hard to really force them to do what you want them to do, but
A lawsuit is not a good idea. Faraz, Brian.
asking for a friend, employer A filed AOS while working for employer B and received EAD-AP. Her intention is to go back to work for employer A after green card approval. Would it be safe to travel on AP while working for employer B? Fundamentally, they should honor an AP while adjustment status is pending. It doesn't hurt to have a letter from employer B saying we have a pending green card application on this behalf. And again, the fundamental bottom of the barrel answer is no guarantee. Is travel safe? The safest way to avoid travel issues is don't travel. It's not practical. There's always a bit of a leap of faith when traveling outside the United States. If you're not a U.S. citizen, the only ones guaranteed to enter, U.S. citizens, passport in hand.
Yes. Nikita Reddy has a question. I have a Consular H-1B approval in 2020 and expiring in 2023. Say I don't use it and get a job in 2024. Can the new employer directly file for my H-1B? The answer is yes, they can. As it's counted against the cap, yes, absolutely.
Well, I don't know. I see a consular H-1B approved, and I know if you read the law, I mean, what are the standards for getting counted against the cap? Having been issued an I-94
or a consular stamp.
Is there a stamp?
Yeah, consular H-1B approved.
I thought they meant okay. This is a different.
So
interpretation.
my interpretation is the consular H-1B approved. I mean a consular stamp.
Stamp. Oh, sure,
because
sure.
it says issued 2023, expiring 2020, expiring 2023.
I'm imagining this.
Oh, so you're reading this an I-797 approval.
Yes, a 797 approval from USCIS, but no stamp from the consulate.
Nikita, you set me up because you said consular H-1B approved, and I assumed you have a stamp. Brian here, that's why Brian is the man, alerted me that it does not appear that you have a stamp. You have an I-797 approval
From USCIS.
From USCIS. And if you do not have a stamp, as Brian explained, or you do not have an H-1B I-94, as I'm assuming, then you have not been counted towards the cap, and you would be subject to the H-1B lottery one more time. Brian, you want to add to it?
So, in this scenario, I have seen cases filed under this fact pattern, and USCIS still consider them counted under the cap, because we know what the law says, but what they actually apply is different, I guess. So it's worth talking to a prospective employer or immigration counsel about that, and I can give you a detailed.
And we've also seen it the other way.
Yeah, it is possible, and they're getting better at knowing their own law on this issue for sure.
So the law is you're not counted against the cap because you do not have an I-94 and H-1B. Brian is right that we have seen some cases get approved notwithstanding because the officer did not know the difference.
Yeah.
But we also have seen it not approved specifically for that reason.
Yeah.
All right.
So I think we've already answered this one, Sam. Yeah. From Ojas, suppose my EB3 downgrade priority date 6/2013 does not get current this year. Well, I need new medical since it will be 2 years after medical. Likely, yes. They do have the means to extend the validity of medical exams if they realize they're creating a massive problem by, let's say, slowly processing cases and they don't want to deal with it. It's possible. There's a very good chance you'll need to do medical exams, but it's not a guarantee.
Sai wants to know, well, you're welcome, Sai. Thank you. My priority is March 2015. Any prediction getting current in 2023 or 2024? Well, I doubt it's going to be current in 2023. 2024 is way too much in the future for me to predict.
I don't give it. I mean, the furthest the visa bulletin has made it for India was January 1st, 2015 for EB3 back in October 2020, and anything they're saying is they don't expect it to be able to get back there anytime soon.
Yeah, I agree. Fine.
So, from Sai Krishna Reddy, I am working on nonprofit H-1B and have consular petition filed by company B, which is expiring in 2024. If I don't plan on joining by September 2024 and get a job through company C in December 2024, is there a follow-up here? I think there is. It's 2 questions down, Sam. That one, yeah. I'm sorry, one below it. There we are. Can company C file for my H-1 as I'm counted towards the lottery in 2021? So I think this might be a situation of not enough information, but I'm going to go back to your first half of the question. Counting against it, I will state the general rule because I'm not seeing the answer to it there. Counting against the cap requires either a 994 to have been issued pursuant to that cap case or a visa stamp, and I don't see any evidence of that. So basically, can I get a job through company C but being counted against the cap? Not unless you.
Well, it's a nonprofit H-1B. So if you're working for a nonprofit H-1B and you're joining a profit H-1B, you have to go through the lottery.
Yeah, which is so. I presume that the company B. So here's what there's so many details, and that's why general information during these sessions you should really speak with directly about your facts with a competent attorney. But I was reading it as follows, Sam. Hey, I'm working in the United States working on a nonprofit H-1B employer right now. But what would that matter? Those nonprofits aren't exempt from the, or certain nonprofits. Certain nonprofits are exempt from the cap. Here's what I think is going on. They're saying, I'm working in the United States right now pursuant to an H-1B status with a nonprofit. And then another company, an actual company, a for-profit company, filed a consular case, got me selected in the cap for a prior year. And that's a scenario I think that's playing out here. But
so she has to leave and get stamped and come back?
Yeah, hasn't got stamped, hasn't got 994 subject to the cap. There you go.
Yes. All right. So my priority is September 2013 EB2, and dates have retrogressed. I have already filed Supplement J along with 45. When date becomes current, will I have to submit Supplement J again? More than likely, yes. You'll be asked to submit a second one because they want to confirm the current employment.
I think that's the second half of Krishna's question.
Okay.
Yeah, we got that one.
Ryan, take that one.
So, got my green card in September 2022, but my downgraded EB3 I-45 is pending. Do I need to do anything? So basically, USCIS, if you have a green card in your hand, eventually they will get around to looking at the EB3 I-45, and they will administratively close it. It'll be scary looking. It'll say, decision notice or denial notice, but usually it'll say, you've gained this requested benefit through other means, meaning you got a green card in another category.
Or you can request withdrawal.
In this crazy world,
you want to wait.
I don't want to wait because so many people in the comments are saying, I think my green card got approved erroneously, for example. And
excellent point.
And even though if USCIS came back and said, hey, we issued you wrong, I'd say, well, I withdrew it in reliance upon that, but
Parth, both of you are doing an excellent job. Thank you by answering these questions for people who are all tied to a thin string of hope in this country. God bless you guys. Well, a really nice statement.
I will administer some hope. I've been doing my job. I think I'm closing in on 13 years now, Sam. And people do get green cards eventually. I'm seeing the names of people who you handed me a stack of 10 H-1B petitions during my first year. So I'm seeing those people getting their green cards.
You're trying to make me look old.
No,
that's what you're trying to do.
I'm feeling old myself.
Yes, it's fantastic.
The statistics say that if you read the statistics, it's something like 75 years to get a green card in certain categories. But strange things happen, and people are getting their green cards on that 10-year time frame. It's not great, but it is what it is.
Yes, I agree, Brian.
Yeah.
Bavish, one of two. Primary applicant green card approved in EB2 last year with priority date of June 2012. Derivative got interview. By the time it was complete, they have retrogressed in EB2. I have approved 9140 in EB2 and EB3. Can I ask USCIS to adjudicate the derivative green card in EB3 category now? It's an excellent question, and now we understand the question. I don't think so.
No. Yeah, they are content to make spouses wait in that scenario.
Yeah. Consider F1 application, spouse of a permanent resident. It may be current now.
Yeah, I believe it still is, and we've dealt with that scenario before actually.
Of course, the derivative, if it's a child, then that's a different issue.
Well, they get the same benefit, aren't they? Aren't they in the F2A category?
But if there's not a spouse, but there's only a child. let's assume the spouse got the green card, but the child didn't get the green card. It's only a spouse. What's the category?
F2A is, we have to look these things up.
Yeah.
That's spouses and children of permanent residents.
Oh,
F2A.
outstanding. So
And F2A
yeah.
is current right now.
So you can apply for an F2A for all your family members and not wait.
Yeah.
And that way is the best way
That's,
to do it.
when you're talking about applying for an F2A, you're talking about filing an I-130 petition, right?
Yes.
Yeah.
Yes. All right. We are on H-1B, H-4, also I-45 adjusted with advanced parole and EAD. Adjusted? Also I-45 adjusted with advanced parole. I think maybe
Just filed AOS. I
Okay.
think is what this means.
It's not. You're not adjusted yet. It's pending.
Yeah.
Just to let you. And this retrogressed. We are planning to have surrogate baby in India. Can I get a baby with with U.S. and I-485 status? It's a fantastic question.
Ooh, that's a complex.
It's a complex question. We've done surrogate cases before.
Yeah, we did. That was a fun one.
Yes, and basically, once you go through the process and the counselor recognize that he is your derivative, you're gonna have to, unfortunately, do a following to join after the green card is approved. This is definitely the kind of case that you want an attorney to dig deep into it for you.
Yeah.
Because once the child is recognized, if the child is born abroad, if the child is born in the U.S., the child is a U.S. citizen. If the child is born abroad, then the child will be recognized as your son, your surrogate son or daughter, child,
Eligible of getting an H4 visa for them in this scenario.
if they have a valid H-1B. Do they have a valid
Yeah, it says
H-1B?
they are on H1B and H4.
So you
I'm
get
just-
an H4, but once it becomes current,
then the child can file for adjustment of status.
and once the adjustment status is approved, then they're fine.
yeah.
So there is avenues and there's planning to be done, and definitely you want an attorney with the
Yeah.
patience.
Just on the family law side of it alone,
Yeah.
making sure that's set up properly so your
Yes.
child is properly recognized as your child
But-
is a big undertaking in
but
itself.
we-
Let it
we-
go in the immigration.
100% wish you the luck with this. I know this is extremely emotional process
Yeah.
and personal process, and exciting as
Yeah.
well. CP, one of two, do I have to maintain H-1B, H-4 still our dates current?
Till our dates are current. And I think the answer, so basically, I think that fundamentally in this scenario, there's a surrogate, a kid who's going to be born to you outside the United States. In order to get that kid to the United States, you have to be maintaining your H-1B or H-4 because having a pending adjustment of status does not allow you to bring somebody to the United States. Having an H-1B visa does.
Yes, excellent point. My priority date for India from Babu is EB2 in September 2012. Any hope of date becoming current in 2023? Well, June right now.
June is current in EB3.
In EB3. So is there hope? Well, obviously 2011 for EB2. Some hope for EB2, not incredibly. I don't have high hope, but yeah, there is.
I'm anxious to see the next visa bulletin, or the April visa bulletin. So that's 2 visa bulletins from now. I'm really interested to see what it does, and
We'll take it
Yeah.
from there. Babu, my spouse has priority date EB2 2010 from their previous employer. 45 was not filed, and no perm I-140 applied with new employer. Their H-1B expires in October 2023. Are they eligible for H-1B extension beyond 6 years? So the priority date is 2010. They're current.
Yeah,
So I'm worried about the answer might be not.
Yeah.
So yeah, I would be concerned that you have a legitimate concern with the extension beyond October 2023. Again, this is something that you need to really get with an attorney now. Don't wait until October 2023. The conversation in October 2023 might be very unhappy.
Yeah, I mean, it's fundamentally, if you have an approved I-140, it generally allows for extensions beyond 6 years. However, when your priority date is current, that gets shut down. There's the other path to extension beyond 6 years based upon the the filed perm / I-140, but that's a real detailed analysis, and we just don't have the facts here to really answer that.
Sriva, are they approving green card without priority date is current? Have you seen any risk of losing someone? So are they approving without priority date is current? They're approving them when the priority date is current, not current when we assume that there was a visa number pulled for that person at the appropriate time.
Yeah.
But we've seen some. Any risk of losing? Absolutely, there is a risk of losing. Why such green cards are issued? Like I said, it could be that the green card number was pulled before it retrogressed and they are finding that out, or it could be an error.
Yeah, we have seen them issue notices to people saying, we issued your green card in error, you're giving it back, we're going to put your I-45 back in a pending process.
Rishi for you, Brian.
Rishi, is USCIS underestimating the EB2, EB3 India forward movements in fiscal year 2023, given there are a number of apps in parallel EB2 and EB3 tracks? That's a hope you have to have out there, but perhaps basically strange, great leaps forward. If you see a great leap forward in the visa bulletin, it means they underestimated demand. Does that make sense?
Yeah, absolutely. Immigration, priority date August 2013, pending adjustment status in EB2. Married to a U.S. citizen, would you suggest filing parallel I-130? Yes, I do. With a new I-45? Yes, I do.
Yeah.
Should we tub? No, I would not recommend a tub to a spouse petition because you need both of them.
Yeah.
I know love is great and you're married forever.
Most conservative answer is leave both of them pending. That's what we're usually in a favor. Yeah.
Any impact on the EB2 petition? No impact on the EB2.
The only impact I see is when they eventually approve the family-based one, they will snuff out the the other one, saying
A T for you, Brian.
A T. You missed my question earlier. Well, we're trying to catch them all, but here we are. Looks like my question is also retrogressed. I very much like that comment. I have a pending AOS under EB2 India, and I just applied for EB2 National Interest Waiver. Can I tub from the employer-sponsored EB2 to EB2 National Interest Waiver? So the tub requires a few things to think about regarding the transfer of underlying basis. One, just as a reminder, it resets the portability time frames for one thing, and. So
I think you can answer.
You can. I don't know.
But consult with an attorney to make sure. But I don't see nothing comes to me in the rules that prevent this transfer underlying basis. All what you do is you're transferring one I-140 to another from approved or pending. It doesn't matter.
Yeah, I just don't know if I see the benefit. I guess if you're going to have a quickly approved national interest NIW case, I suppose quicker path to a green card.
Raja Shikar. Hello, Brian and Sam. USCIS said I won lottery, approved my 45, but next day they said we don't have a prize money. Respond my case on September 7 last year. Yes, same day they exhausted visa number.
So people are in the comments asking, do they ever do this? Raja Shikar is a great example of this.
Yes. My question, can I consider my file is good faith to get green card when date was current and visa available? My priority date August 2000, thank you.
So it is more than possible that they will have new questions for you when your date becomes current. They may ask for a supplement J. I would think in that embarrassing scenario, they'd be more likely to just, forget about those things, but it's very possible for them to ask you questions again before they approve your case.
Yes. I have an EB2 approved I-140 with priority date 2018, and now I have upgraded to EB1C. Now with EB1 retrogress, can I use EB1 to I-140 priority date for EB1? Yes, you can, but it has to be current to be able to transfer basis.
Yeah, it looks like, I believe that's, I have, here we go. EB1, April 2018 is going to be current for everybody. Yeah, so, yeah.
Yes. My priority date is April 2012. EB2 will be current this year.
April 2012 EB2.
You have a good chance.
Yeah.
I would say you have a good chance.
Yeah.
Adi Bum, Brian.
I have valid H-1B visa stamped until 9/2025. If I leave my employer and move out of U.S., can I re-enter USA without another visa stamp as long as new employer files H-1B petition? before September 2025. Basically, I think the question is a very simple one. And the answer is this. Hey, does my H-1B visa, is it still valid when I change employers? The answer is yes.
Yeah, I agree.
Yeah.
Immigration. India citizen, so downgraded and upgraded. Hope seems bleak in EB2 right now. Well,
yeah,
we agree, but hang in there. Morale, I have an I-45 EAD and advanced parole, but continue to keep working on H-1B. What are the pros and cons of traveling to India on an advanced parole? Well, you don't travel on advanced parole, you enter the US on an advanced parole. If you don't have a stamp or unable to get stamp, coming back on an advanced parole and rejoining your H-1B employer gives you an opportunity to reclaim your H-1B. So I see more advantages than disadvantages in that direction.
Yeah.
Please advise on the timeline for approval in family-based category. Would I need to be filed in California Center? I live in California. What is the typical attorney fee for family-based filing? Great questions. We don't discuss fees here, or filing location is more of a case specific, and I don't have them committed to memory. You give me a lot of credit for for thinking that I can remember them. The last one, thank you for answering all the questions. Amazing session.
Yeah,
you're
must
welcome.
be a little bit thirsty. I think we've made it to the end of all the questions.
Thank you, guys.
We did. It's
An hour
possible.
34. Yes, wonderful. So that gives us hope that we will do this again. Thank you so much for listening to us. I hope this was a helpful and productive session. Give us feedback if you would like to see more of those simply Q&A sessions.